All right. Well, good afternoon and good morning, everyone, and welcome to Thrive in 2025, a monthly webinar series brought to you by ArcPoint, where we empower business leaders to create compliant, high-performing, safe, and healthy workplaces that thrive. My name is Ryan West, your host and Thrive specialist, and proud partner of our expert presenter today, Miss Leslie Prince, founding partner of Compliance Systems. Before I introduce Leslie and she takes the virtual floor, I have a few brief announcements. First things first, to the entire ArcPoint team, our corporate staff, our dedicated owners, thank you all so much for the work that you continue to do and for helping to make this webinar a success. Just not possible without all your support. So thank you all so very much. Second, this webinar is being recorded, and the recorded will be posted to ArcPoint's website, usually within a week. It's usually fairly quick. So if you're in the airport, if you're on a commute somewhere to and from a business engagement, can't take notes, can't fully engage, not a problem. You can check out the website recording and fill some of the gaps that you miss. Third, ArcPoint is proud to be a recertification provider through Sherman HRCI. So if you are a credentialed HR professional, you will receive one recertification credit and one professional development credit upon completion. I will post the IDs also in the chat at the very end of the webinar today, and the IDs will also be listed on your certificate of completion, which will be emailed out to all attendees by end of day on Monday. But you must attend the entire webinar to get that certificate. Fourth, we hope that you can join us for our Thrive series throughout 2025. This kind of officially kicks things off, which I'm so excited about. March 20th, I'll be presenting Identifying and Responding to Workplace Impairment. And that virtual training is aligned with the DOT requirements for reasonable suspicion supervisor training. So if you need that type of training, please join us. You will need to reach out to your local ArcPoint Labs provider for that particular training. All the other trainings are advertised publicly. That one's private. So if you want more information about that training, about how to register and attend, please reach out to your local ArcPoint Labs provider. And then on April 24th, another Thriving Thursday topic, Miss Shelley Jackson, attorney with Krieg DeVault, great topic, another dynamic presenter, is going to help us navigate mental health and substance abuse issues in the workplace. So talking a lot about policy today, I'll be talking about identification and response, and then Shelley's going to kind of round out the Q1 series of what do we do about the individuals who are struggling with mental health and substance use issues. Fifth, please take a moment after today's webinar to complete the post-webinar survey. I will also post a survey link in the chat towards the end. Click on the link, follow the prompts, completely anonymous. Your feedback is absolutely reviewed by senior leadership here at ArcPoint. We take your comments to heart, and we select topics and speakers based on the comments that you give us. We want to make sure these webinars are worth every second of your time, your valuable time in this very fast-paced world. Which brings me to my last announcement. To make the most of your time today, please engage with our speaker, with each other, using the chat and Q&A. If you have a question, please try to use the Q&A function. We're going to have a lot of people on this call today. So if you put a question in the chat, we might lose it. I don't want to do that. So if you have a question, use the Q&A and use the Q&A for everything else. Leslie, I'm going to pitch her some questions about halfway in, and then she's going to leave us about 10 to 15 minutes at the end to field some more questions. And on that note, I am so pleased to introduce our speaker today, a DOT drug testing program expert, among many other things, proud partner of ArcPoint Labs, founding partner of Compliance Systems, Miss Leslie Prince. Leslie brings more than 30 years of expertise in developing and implementing substance abuse testing programs for employers. She consults with motor carriers across the country on DOT regulatory compliance issues, such as driver onboarding and file maintenance, providing practical solutions so they stay out of the ditch, both literally and with federal regulators. Leslie is a nationally recognized leader in the drug and alcohol testing industry, which I can absolutely attest to, and currently serves as the vice chair of the National Drug and Alcohol Screening Association's, or NDASA's, training committee, and as NDASA's Georgia State affiliate. Welcome, Leslie, and thank you so much for helping our clients maintain a compliant DOT drug testing program in 2025. The floor is yours.
Awesome. Thanks so much, Ryan. Appreciate it, and appreciate the opportunity to present to you all and spend some time hopefully answering some questions and maybe providing a little clarity about what's coming down the pike, because there are some changes that are coming, and you need to know what to do. So we're gonna just kind of cover four basic topics today. Number one, who's involved in your policy, who's involved in your program. We're going to talk about your role as the DER, or designated employer representative. We're going to make sure that you, as the DER, understand where you've got to go, what you've got to do, when you've got to test, what we're testing for, that sort of thing. And then again, we are going to address some of the changes that are coming, specifically the oral fluid testing. And we'll just provide some good insight as we go through. So, as Ryan said, please don't hesitate to pop those questions in. And then if we run out of time and we don't get to your question, we will respond back personally to your email. So please don't hesitate to answer or to ask those questions. We'll try to get them answered as quickly as we can. All right. So you are the DER. Congratulations. Merry Christmas. You have a new title. DER stands for Designated Employer Representative, and that's the person who has been acknowledged or designated by each company as the individual responsible for the drug and alcohol testing program. So you are the one who the folks at ArcPoint are going to contact if they have questions or issues. You will be receiving information input from them, from other collection sites if you have multiple locations and you're using other sites. You will be also receive the drug test results. So it's important that you know exactly what those drug test results mean. So if you get something that's other than just a straight old negative result, what do you have to do? So we're going to talk through that today. And you actually have to have the responsibility from your employer to remove someone from a safety sensitive function if you learn they have a positive test result or have refused a test. So we'll talk about what the prohibitions for your employees are, what the consequences are, and then how you react to those if you have somebody who has a rule violation. You must also, as you do your job, you must also know about the DOT rules. Also, what the testing process is. We're going to talk through that. You know, a drug test is really a three-legged stool: the collection, the lab, and the MRO. So, what do each of those roles play? You have to know about your state regulations as well, in addition to the federal regs, because if you have a non-DOT testing policy that accompanies your DOT policy, you've got state laws you have to adhere to there. And some of those state laws have gotten complicated. And with the marijuana laws, we talk a lot about marijuana around here. So you've got to know what you have to do as far as your policy in terms of your state laws. Also, if you're a union shop, you have to understand your company, your collective bargaining agreement. And then most importantly is your company policy and how you implement that and how that rolls out on a daily basis. So those are the things we're going to talk about today. But you, as the DER, are the one who's guiding the ship. If you've ever been on a cruise ship, when you pull into port, a local person, a local captain gets on board. They're the harbor pilot. They're the ones that they know the ins and the outs of that particular harbor. They've lived there a lot of times their whole life. And so you are the harbor pilot. You've got to be the one that knows the ins and outs of your policy, the regulations, and you've got to be able to steer that ship. So let's look at the components of a drug testing policy or a drug testing program. Number one, the foundation of the program is your company policy. You must have a separate DOT policy from your non-DOT policy. A lot of times we'll see companies that try to mix and mingle those policies, and it just flat out doesn't work. You've got so many things that your DOT covered employees have to adhere to that may not apply to your non-DOT, and vice versa. So it's really super important that you delineate what the policy and the procedures are for those that are covered by the federal regulations and those that are you're just testing under your company policy. If you have a full-blown plan, some of the policies are, 50 pages long. It's also helpful for you just to have a one pager, what I refer to as a one pager, that's a summary of the policy that you can put into your employee handbook. You're not going to put all 50 pages of that policy in your handbook, but you do need to, if you do have a handbook, you need to make sure that your applicants and your employees know what's the high points of the policy, and then also where they can go to see the in full policy if they ever had a question. You have to do drug and alcohol testing, excuse me. Mm. So, if you're if you're regulated by federal regulations, you have to do DOT testing at certain points in time. We're going to talk about that today. Your company policy is also going to flow along with that DOT policy, and you may have some situations where you do non-DOT policy. For example, if you have a CDL driver, so if you're a trucking company and you have a CDL driver who has an accident that doesn't meet the DOT criteria for a DOT test, but your non-DOT policy is going to kick in, then you have to know the difference between those and you have to know which test to do. You have to be able to tell your ARC Point representative if they're going to do a DOT test or a non-DOT. You don't want to get those mixed up. Training and education is important. So Ryan is doing a fantastic signs and symptoms training, I guess, next month and then in May. So if you need that 60, what we refer to as 60/60 training, the DOT says that supervisors have to have 60 minutes of training for drug awareness and 60 minutes of training for alcohol awareness. If you or any of your supervisors need that training, please do contact your ARC Point owner so you can get set up for that and you can attend those trainings. You do need to have that training if you ever require someone to do reasonable suspicion testing, you must have proof that the supervisor who designates that that test is required has been trained. The DOT would ask to see that if they ever audited your records. So just make sure that all your supervisors have been trained. It's also a good idea to have employee education. The different agencies, so when we say agency, we mean the different modalities. So FMCSA for trucking, FAA for aviation, FTA for transit, and so on. But they all have specific requirements as far as it providing education to employees. Sometimes it can just be written material, or you can, e-blast out an educational topic, just little bit of an email. That's fine, but you do have to provide some type of education for your employees. And then professional services. So there's some things you've got to do that sometimes we don't think about. So if you hire a new employee, if you are under FMCSA, if you're a trucking company, you have to do that 3-year drug and alcohol history records check. Now that can be done as part of the clearinghouse. If you are in any other agency, that's a 2-year check, but you still have to do that. FMCSA obviously has to also do the safety performance history, but you do have to make sure that you're doing both the drug and alcohol history records check for everybody, and then again, if it's FMCSA, an additional safety performance history. And your ARC Point folks can help you with that. We have some great resources to help you check that box. Also, you have to have a SAP, a substance abuse professional. If you have somebody who fails a drug or alcohol test before they can resume their safety sensitive duties, they do have to go through the SAP return to duty process. So you do need to have a SAP on board for that. And then EAP services. So employee assistance programs are fantastic programs that can help employees, hopefully proactively, if there are someone in their family or developing drug or alcohol addiction, we can get them some help. It also helps with a wide variety of topics. So if they've got parents that are got it Alzheimer's, or they've got kids that are driving them crazy, or whatever, EAPs are great resources to help with that. And ArcPoint has some fantastic resources for you. But these are the components of your drug testing program. So you just want to make sure that you've got it all in place so you're not going to get in the ditch anywhere. So let's just review the reasons for testing very quickly. We're going to start, of course, with pre employment testing. So, anyone who is in a safety sensitive position must have a pre employment test before they begin their safety sensitive functions, especially if you've got someone who's transferring from a non-safety sensitive position into a safety sensitive position. So let's say, for example, you've got an employee who's been working in your warehouse, but they went to CDL school and now they've got a CDL license, and so you're going to put them into a truck. Well, they may have worked with you in the warehouse for 15 years, but before they drive the truck for the first time, they have to have that pre-employment drug screen. And oddly enough, it has to be a negative test result. So just make sure that if you're transferring positions, you don't forget to do that pre employment drug screen. Random testing is reason for testing that we spend the most time talking about, because once somebody's on board, then random testing is the other reason that that you encounter most frequently. You've got to do it at least quarterly, so you're encountering that random test at least 4 times a year if you're under a federal program. Um, each of your employees who are covered in that particular pool must be in the pool each time a list is pulled. So if you had somebody who was selected for your first quarter selections, they've got to be in the pool again, for second quarter, third, and fourth. You can't take them out just because they've already been selected for the year. Um, they're going to complain about it. It just seems that that's the way it works. I always thought it was just our software program that got somebody's name and hung on to it. But every time I go to some of our industry conferences, everybody's complaining about the same thing. And we're all using different software programs. So it just happens. Someone's going to get picked multiple times throughout the year. I just tell them, congratulations, you win the Golden Urine Cup Award, and they've just got to move on. Now, once you've got your random test list, you've got a couple things you need to remember about getting the test accomplished. Number one, you want to make sure you know the hours that your ArcPoint office is open. Some of them have different variety of hours. Some of them stay open later than others, but just make sure that you know the hours that your ArcPoint is open. Also, if you have locations that are using clinics outside the ArcPoint system, make sure that you know those hours as well. The reason for that is because we'll talk about this in a second, but if somebody goes in for a test, they can't provide a sample, they have to sit and drink water. You don't want to send them at 4 o'clock if the clinic's going to close at 5. So just make sure that you give that person time enough to get the test accomplished. You also want to make sure that the employee can report to ArcPoint immediately. Don't tell them at the first of the day, hey, on your way back after your route, swing by ArcPoint and get your test done. You don't want people to have the opportunity to study for their test. You want to make sure that they can go immediately. That is what the DOT regulation states, is that once you notify an employee for testing, they must immediately stop what they're doing and they must go in for testing immediately. Can't stop and get lunch, can't stop and see their kids, can't pick up their kids. That's what we hear most often. Oh, I can't stay. I've got to go get my kids. You've got to make other arrangements, because if you leave the clinic or the lab before the test is completed, that is considered a refusal to test, which treated as a positive, and you'd have to be removed from your safety sensitive duty. But while you're, as you are making sure that it's convenient for the person to go for an operational perspective, you also want to make sure they do have those kids at daycare. You want to make sure that you're giving them enough time to get that test completed, especially if you know they do have children at daycare and they're going to get charged $20 a minute for every minute they're late picking them up. Don't put that person in a bad position. It just doesn't do good things for morale. You're forcing that employee to make a tough decision. Do they go get their kids or do they keep their job? And so make sure that you're just giving them plenty of time to go. Also, overarching is, if you all of our specimens for DOT testing have to go to the lab. We cannot use instant tests for DOT testing. Because of that, the specimens go overnight via FedEx or whatnot to the lab. It takes at least a day for the testing to be completed. If your person goes late in the day, if you send an employer an applicant late in the day and FedEx has already picked up for the day, that specimen's going to sit there another day before it begins testing. And so it's just going to delay the time that you get your result. So again, make sure you send your person earlier in the day, make sure you know what the clinic or the lab hours are, and make sure it's operationally convenient for them to go, that they can go immediately. Don't give them time to study. So that's random testing. A couple other things, reasonable suspicion. So this is you believe or you have reason to believe that a person is impaired at work. You must make this determination based on specific contemporaneous. So contemporaneous means now. It's like you think they're drunk now, not 2 weeks ago. Articulable observations concerning appearance, behavior, speech, or body odors of the employee. So, they get out of their car and they smell like a distillery, or they smell like a marijuana factory. You want to make sure that you've taken that into consideration. If you have that, you're testing them right away. There are time limits after you make that determination. If it's an alcohol test, you've got to get that alcohol test done quickly. So make sure you're prepared to do that. So we're going to talk, I'm not going to talk anymore about reasonable suspicion because Ryan's going to delve into that next month. So we've got that covered for you. Post accident. So, again, most of our folks that are on the webinar today are in the FMCSA space. So you're in the trucking business. The FMCSA has a specific criteria that an accident has to meet before you can do a post accident test. Number one, it has to be on a road. So if your accident happens on the yard, in a driveway, on a job site, that does not meet the DOT criteria for an accident. The other criteria we refer to as hearse, nurse, and tow. So hearse is there is an accident and someone is killed, and it doesn't matter who's at fault or what has happened. Your driver has to have both drug and alcohol testing. So make sure you know that. Uh, Bodily injury with immediate medical treatment. So that's pretty much the ambulance comes in to this accident scene and takes someone away for immediate medical treatment. If your driver receives a citation and someone goes away from the scene for treatment, then your driver has to have post-accident testing. That's your nurse. And then the last one is your driver receives a citation and one of the vehicles is towed. That's your tow. So hearse, nurse, and tow. So fatality, driver gets a ticket and someone is transported for medical treatment, or driver gets a ticket and someone is towed away from the scene due to disabling damage. So those are the only three criteria that it has to meet before you can do a DOT test. So if you have a fender bender and your driver's not at fault, or if there's an accident and your driver's not at fault but someone is towed away, you should not do DOT testing. You can do non-DOT testing, but you should not do DOT testing. Obviously, all of our agencies, so pipeline, aviation, transit, railroad, and Coast Guard, all have their own definition of post accident. So make sure that you understand what the definition of a post accident is for your particular agency. Return to duty testing. This is not if someone's been off the job for medical leave or military leave or maternity leave and they're coming back. This is only to be used if someone has had a positive test. They've been through the DOT's post-act or the DOT's substance abuse professional program and they're coming back to work. That's the only circumstance for return to duty. If you take somebody out of the test pool and they're coming back to work for a particular leave, then they have to have a pre-employment test. So return to duty is only after they've had a positive test or refusal, they've been through the substance abuse professional return to duty program, and they're coming back to work. And then after they've been back to work, they have to have at least 6 tests in 12 months. So that's your follow-up testing. So they're sort of in their own little random testing program because we're just monitoring them to make sure that they're not using again. So that's return to duty and follow up. And those two reasons for testing are only if you're bringing someone back to work after they have failed a drug test at an alcohol test of 0.04 and greater or have refused a test. Those are your particular reasons for testing. If you have any questions about that, now's a great time to pop those in the Q&A and we'll come back to them in just a minute. So let's just talk real quick about the drugs that are on the testing panel. There's actually 13 of them, I believe now. They added the synthetic opiates back in 2018, so that really expanded our panel. We talk about marijuana the most just because obviously we have the most questions about that. We have, it's very prevalent in our society now. So I grew up in the 1980s. President Reagan was in office, and Nancy Reagan was our first lady, and her big platform was just say no. That's what we grew up with. And that's what I'm telling you now for CBD and Delta 8 because we get lots of questions about that from our employers. Can my employees use these products? Well, I'm not here to talk about the efficacy or whether they are good products or bad products or they're helpful or they provide great relief. I'm not talking about that at all. I'm just talking about this from a drug testing perspective. So let's look at CBD and Delta 8 for just a second. So in a DOT drug screen for marijuana, we are specifically testing for Delta 9. We do not test for Delta 8. We don't test for CBD. We're just specifically testing for Delta 9. It is, partially legal in many states, both for medical use and recreational use, but the DOT does not care about that. And so medical and recreational marijuana is not an excuse for a positive test, regardless of what state that you live in. CBD, which comes from the hemp plant that has been bioengineered to have very low THC content, is legal in most states. Um, and but just remember, there are lots of studies out there that show that the CBD content that is on the label is usually not what is in the jar. Mayo Clinic did a study about that several years ago, and they found that a substantial percentage of CBD had a higher THC content than is on the label. Some of it actually had no THC. It was just some kind of oil. So just make sure that that your folks are aware of that. And then Delta 8 in rare time, occasionally you see it that has come from the hemp plant. Most of the time it is synthetically made. It can lead to a positive test just because many times when we see Delta 8, we see Delta 9 as well. So, again, I'm going back to my high school days of just say no. So please keep that in mind. And these are great topics for your safety meetings for your employees. Just say no. Make sure that you're telling your drivers and your employees who are covered that, you know, CBD and Delta 8 can get them into trouble. I don't believe many people when they tell me they tested positive because of CBD, but I believe it occasionally. So just be aware of that. Okay, just want to bring up one thing about prohibitions for drugs. A lot of folks have prescription medications. Some of those prescriptions can cause them to be impaired. There will be a warning label on the prescription. Their doctor, their pharmacist may tell them that this medication can make them drowsy. Employees cannot perform safety sensitive functions while they are taking these medications. It's not that we don't want them to take the medications, they just can't do their safety sensitive function while they're taking them. So if someone comes to you as the DER, as a manager, and says, I'm taking this medication, and sometimes they even show you the bottle and it has the warning label on there. Just make sure that you remove them from their safety sensitive function while they're taking that medication. And then obviously, if it's an illegal drug, they cannot take that at work if that impairs them, and you, as the employer, can't allow them to work if you know they've taken anything. Consequences if someone fails a drug or alcohol test or has another violation, then they have to be removed from duty until they go through the substance abuse professional program. So those are your prohibitions and consequences. Just want to make sure that we're clear about prescription medications and people letting you know when they're taking them. Also, make sure your folks know another great topic for your safety meetings is that it is illegal to take someone else's medication. So we see this a lot with amphetamines because employees' children will have a prescription for Vyvanse or for Adderall which does contain an amphetamine. They've been given that for attention deficit disorder, and the parent will take it. Sometimes they take it mistakenly, sometimes they take it intentionally. But if they take a prescription that has someone else's name on it, that technically is federally illegal. And that's a positive drug screen, just like if they snorted a line of Coke. So just make sure your folks know that it is illegal to take somebody else's medication. And if that's the case, if we got that excuse on a positive drug test, it would not explain the test. Okay, so we're back to, so we've talked about the drugs, we've talked about when we test. Again, if you've got questions, put those in the Q&A. Let's talk about some collection issues. We kind of talked about that a little bit. But I just want to make sure we reiterate that. So again, if someone comes to the lab, if they come to ArcPoint for their collection and they are not well hydrated, we have to allow them to drink up to 40 ounces of fluid, and they have up to 3 hours to provide a specimen. That's why it's so important to know what the hours are that your local ArcPoint is open, or that the clinic where you're using is open, so that you can accommodate that and you make sure they've got plenty of time to give their sample. If they give us a tampered specimen, a cold specimen, hot specimen, or a synthetic specimen, a fake urine, we're getting a lot of those now. We have to package that up. We have to send that to the lab, and they have to stay and do a second collection that must be collected doing direct observation protocol. That's not fun for anybody. That means we literally have to go, someone of the same gender has to go into the bathroom with them, watch them use the bathroom. Not fun at all. But that we have to do that if they give us a tampered sample. If the employee refuses to cooperate with any part of that collection process, if they refuse to stay and drink water because they couldn't provide us a sample, if they refuse to do the observed sample because they gave us a fake urine and we busted them on it, then that is a refusal to test. And that refusals to test, again, are treated just as positives. So these are the two big issues we have at the collection site. If you have someone who calls and says, hey, I can't stay, I've got to go get my kids, make sure you tell them, stay, because it's a refusal to test if you don't. All right, at the laboratory, so we collected the specimen, it goes to the lab. When it gets to the laboratory, they check the specimen, they check the paperwork, make sure everything's good, and then they do the screening test. If the screening test is a presumptive positive, goes on for confirmation. Confirmation is a very final, very scientific test. If it's positive on the confirmation, it's reported as positive. It's reported to the medical review officer. The only way that a donor can contest a test result is by requesting their split be tested. So we have to send the second sample, because when they use the bathroom, we pour it into two bottles. We have to send the second bottle to another lab for reanalysis. They cannot give you another sample. That's the biggest thing. I hear it all the time. The DER will call and say, hey, the employee says he's happy to come and do another test. You can't do that. You have the only way they can contest their test result is a split specimen. And then all results, including even negatives, are reviewed by the medical review officer. The medical review officer is the physician who's been trained to review test results. If the lab test is positive, the MRO has to call the individual and go over their test results with them. Sometimes we have to get you as the DER in the mix because we can't get in touch with them. But typically, by the time we release the results to you, we have already contacted the donor and gone over their prescriptions with them. So if you get a negative test, that's great news. You can use them. They can start their job right away. If it's dilute, we have to retest them. And that is if it's in your company policy. You have an option with a negative dilute test. And the with the negative dilute test, if you put it in your company policy that you're going to retest, you can retest one time. You cannot retest repeatedly, and it is not a direct observed collection. So we have to, you have options if you want to retest on a negative dilute. We always encourage you to do so, because beating a test result is most easily accomplished by drinking a bunch of water and trying to flush out your system. That's no secret. All right, positive tests. Bad news. You can't use them. They have to go through the SAP return to duty process, and they cannot assume the safety sensitive function. Adulterated or substituted, they tried to cheat and they got caught. So those again are treated as positive test results. And then if you get a canceled test, that's because something just wasn't right at the laboratory. Maybe there was an interfering substance that interfered with the test process, or maybe it was so dilute that we couldn't test it. The MRO had to cancel it, and then we will send you back a note on your MRO result. It'll say test canceled, recollection required. Typically, it's recollection under observed collection procedures. If your employee refuses to do that, that's a refusal to test. So that's how the results are treated. The big thing just is make sure you understand negative dilute. You've got it in your company policy what you're going to do, and that you understand that adulterated, substituted are treated as positives. So we are now somewhere. Okay. If we have questions, this is a great time to put them in the chat box. I'm going to stop. Ryan, do we have any questions?
We've got a lot of questions, Leslie.
Okay.
Yeah, we do. Why don't we start from the very beginning? We'll go back to the
Okay.
beginning. Sarah asked, what's the best way for a DER to have documented proof that they issued a drug and alcohol test? Let's say for a random pool, for example, that I could submit to clearinghouse when we have a refusal to test / positive situation.
Sure. So you do have to have documentation of the refusal. You need to make sure that you've got, and we have some forms. ArcPoint has a full clearinghouse process. We're going to talk about that next. And we've got some kind of a toolkit, if you will, or a compliance package that we can offer to you, and that has some of the forms in there. But you do have to make good documentation, and you have to upload that to the clearinghouse. So if somebody refuses to go, you would just document the time that you notified them. And you also have to document where you were telling them to go. So what lab or what clinic you were telling them to go to, and just put what their response was. If you can get them to sign it saying, I acknowledge that I refuse, that's best. But if you can't, you have to make careful documentation. If there's any way you can get another supervisor, especially another supervisor who's been through reasonable suspicion training, to corroborate that with you, that's the best. But just careful documentation. And Sarah, also let me say, make your documentation right away. If you say, oh, I'm busy, I've got to answer this call, and I'm going to do that when after lunch, you're going to forget about something that happened. You're going to forget about part of your conversation. So stop what you're doing right then and make your documentation. And if it is a CDL driver that has to be uploaded to the clearinghouse, we do have to upload that documentation as well.
Awesome. Thanks so much. Great questions, everybody. I can see that more and more are rolling in. Keep them rolling in. And as Leslie said, if we can't address them all today due to time constraints, we'll make sure they get addressed in follow-up emails. Deanna asks, are you saying that the FAA is requiring 2-year checks now, not 5 years?
So 5 years for pilots, 2 years for everyone else. And I haven't seen that changed, but consult the FAA regulations before you make that. But I know pilots if they have to be under the PREA, the Pilot Records Improvement Act. So you do have to do 5 years there, but I think everybody else is just 2, but we'll double check that.
Okay, great. Dana has submitted several questions. We'll start with the one. Do you have to have a SAP, or can you simply provide referrals to a SAP? For example, she says we terminate anyone who was positive, and we give them a letter with 3 referrals to various SAPs.
That's perfect. Yeah. You just want to make sure that you have access, you've done some research, and you've got somebody that you can refer them to. If you're terminating, you don't have to do anything more.
And a follow-up, Dana also asked, but if you do non-DOT testing, you cannot report it to the clearinghouse if they're positive, right?
That's correct. So only testing done for FMCSA. So if you're in transit, so if you're like in the municipal bus service and you've got CDL drivers, but you're testing under FTA, you don't report those positives either. It's only testing for CDL drivers done under FMCSA. And that's our next topic.
Perfect. Cheadle, I hope I'm pronouncing your name correctly. Regarding return to duty testing, do I have to randomly send the driver, or will ACP send request?
So you will someone has to notify the driver to go. And that needs to happen at the local level. So if it is, if you as the DER are responsible for doing that, that's your responsibility. If you're responsible for just notifying the manager and for that driver's manager, and that manager notifies them, that's okay too. But somebody locally needs to notify them, because if they're going to refuse to go, you've got to have that documentation that they're refusing.
Beautiful. Leilani asks, what can you do if you test someone yourself and they test positive, but then they're sent to the lab and they test negative? We've never had that question before, right?
Okay. So you are talking about if you're doing an instant test as part of company policy, you're doing that on site. And then we've got, I know several companies that do the same thing. They test them there. If they test positive, they don't want to send that specimen to the lab. They want to send them on for someone else to do the full chain of custody. That's really the chance you take. And the reason for that is, number one, if you are sending them to the clinic, or sending them to Arc Point, they can stop by, their local gas station and get a big gallon of water and drink it on their way and flush their system. Um, it could be that, when you got that positive test result, they were right on the border. And even just normal, they had to drink water to give a second specimen at the lab. They fell below the cutoff limit. So the instant tests are just sort of an approximation. They're calibrated about at what the lab cutoff limits are. But the lab cutoff limits are very scientific. For example, in marijuana, if you test at 49 nanograms, you're negative. If you test at 50 nanograms, you're positive. And so that's probably what happened there on that test result.
Beautiful. Janet asks, what is the protocol if an employee has to be tested after clinic hours?
So most of our ArcPoint offices do have after hours services. So you just need to let your local team know. I mean, it's great to be proactive about it and not wait till you have a crisis situation where you're trying to figure out what to do next, but go ahead and make sure you've got those arrangements made. And if that particular ArcPoint owner doesn't, they'll help you find somewhere that does. And if you have locations across the country, we can help you find the network of providers. So that's really important, especially because, as we learned with post-accident reasonable suspicion, with alcohol, you have a really tight time limit.
Yeah. And I'll just reiterate on that too. So many of our owners do offer on-site mobile testing for second, third shifts. We pride ourselves on that. Not every owner does, but many of them do. So please, if you have any questions about that, reach out to your local provider. Anonymous asks, so a drug test will return positive for CBD?
So it could, because if, number one, like I said, many times the CBD that is in the jar, the actual product, has more THC in it than is on the label than it should have. Also, remember, THC is cumulative. So if you use it over a period of time, it accumulates in your fat cells. And so it can cause, if you're using CBD that has a higher THC content and you use it repeatedly, you could test positive, because the CBD or the THC that's in that will accumulate over time, and it will eventually put you over the threshold. Not saying it all will, but it could. And so we want to make sure that we're very cautious about that.
Yeah, also just to, again, to reiterate what Leslie has already said, I am a DO2 qualified SAP, but not conducting evaluations so much these days. My focus is education. So I get a lot of referrals from SAPs to provide education to their clients that failed, a drug test or refused. And the overwhelming majority comfortably can say 80 to 90% are sent to me for THC. And a good subset of that population is for CBD products or Delta 8 products. They weren't necessarily intentionally trying to get high, but they're failing these tests, having to go through this process. So I love Leslie's comments earlier. Just say no. Just think of that movement, which I honestly didn't love, wasn't super effective, but in this case, it's another anonymous question we got. If an employee has a random and the result is adulterated, do we have to allow them to take another test under direct supervision or observation?
No, adulterated and substituted are considered to be positive tests. So you would not send them back. The only time someone would ever have to go back is if the lab had reported their test result to the MRO as invalid, meaning there was something quirky with the specimen, and the MRO went through the MRO review with the individual. There was no medical reason, and the MRO issued the report. You would, as the DER, would get the report that said canceled, but they would say recollect under direct observation conditions. That's usually what happens. Sometimes in the summer, we don't require recollection because it's obviously the specimen in like maybe it took a couple, 3 days to get to the laboratory. Maybe it got really hot. And so we don't require the observation, but by and large, the recollection is under observation.
Teresa asks, how can the employee request a split test?
You have to do that through the MRO. The employee has 72 hours to make the request through the MRO, and the MRO must immediately put the request into the laboratory to have that split specimen sent to another laboratory. Let me just take this time for a public service announcement for our ArcPoint owners. You as DERs must pay the bill for that split specimen. You cannot deny someone the opportunity to have their split tested because they can't afford it. So just make sure that you're aware of that because sometimes those bills are a little high. The process is very specific, and it's one of those things. You got to pay it. You can request the person to reimburse you or take it out of their last check, but you cannot deny someone the option to have that specimen tested.
Love it. Deborah asks, for a pre-employment test, is there a delay in getting if there is a delay in getting the result, is there a time frame that we can just send them for another test, especially if the sample is not showing with an MRO?
Yeah, that happens a good bit. And I have a bag of specimens I sent 2 days ago that's sitting at FedEx in Memphis because of the weather, and sometimes that happens. Um, we can encourage, I usually give it at least a week, if not 10 days or so to get there, because what you don't want to do is send them back for a second test because we think the first one is lost, and then that test is negative, but when the first one gets to the lab, that one's positive. So, um, you've got to communicate with your ArcPoint folks to find out exactly, where the specimen is. If it's just a flat out loss, then usually a week or so you can call it lost and send them back.
Okay. Four more questions, Les. You still good?
Yeah.
Rolling along here. I love it. Anonymous asks, I have employees who are on prescription medication, that is to assist with addiction, so MAT, like to wean them off, but we work in traffic. Are there any precautions to take?
So, if someone has to have a medical card because they're a commercial driver, and that's defined at 10,001 pounds and more gross vehicle weight, the only drug that, or one of two, I think, drugs that the FMCSA says you cannot have a medical card while you're taking is methadone. So just make sure that they're not taking that if they need a medical card to drive a truck of any of 10,001 and over. 10,001 pounds and over. I would, so what you could do is I would require maybe a fitness for duty evaluation. Send them to your local occupational health physician with specific information of what your information you're looking for. You want the physician to do an evaluation to determine if if they can work. So, um, sometimes with drugs like that, we don't pick them up in a drug test, but you can always require a fitness for duty evaluation just to make sure. I refer to that as sharing the liability. You also want their treating provider to weigh in on the situation. And so you would definitely need a letter of clearance from their treating provider and the treating provider needs to know what their job is. If they're doing something that's dangerous, they need to have that job description before they make the determination.
Okay, Morgan asks, can you please review DOT history check protocols for employees that are new to the company and those that were employed previously, but new to the safety sensitive role?
Sure. So
Okay.
I'll start with FMCSA. So if you have a driver who has had a driving position for any company has a DOT number, you have to do a 3-year drug and alcohol history check. Again, now we've got 3 years of data in the clearinghouse, so you can use the clearinghouse pre-employment query. You still have to do for drivers the safety performance history, which is where you have to write back to any company where they've had a driving job for the last 3 years. Ask if they've had any accidents and other adverse safety history. So those two things are required for drivers. For other agencies other than FMCSA, again, my understanding is it's a 2-year check. And then of course for pilots under PREA, it's a 5-year check. So that's just drug and alcohol.
Okay, two more. Susan, we've got, or three more, just saw one comment in the chat. Susan asked, we had an employee who had something like too much protein, and during the observed result was the same. The outcome was to drop it. Is that correct?
Too much protein. I've never heard of, oh,
Was the
hmm.
creatinine, perhaps the creatinine
I
level
was gonna
was
say maybe
high?
it was the creatinine was high, but usually the creatinine's low when you get into dilute. I'm not sure. Why don't you do this? We'll give you our contact information at the end of our presentation today. Send that to us and let us uh, research that a little bit further because I just want to make sure I'm clearly understanding your question.
Yeah, Susan, and if you would like to go to the chat or back to the Q&A, if you want to clarify or provide more detail, that'd be great too. But we'll, like Leslie said, we'll look into that. And then Cheeto asks, says, thank you so much for answering their previous question. When I send the driver, do I marking return back or on other form, etc. for the next 6 times I send him?
Okay. So if the driver is coming back to work after they failed a drug test, alcohol test, or refused a test, then they have to have that return to duty test. So you're going to mark on the authorization form that is a return to duty and also make sure it's observed because return to duty and follow-up test collections have to be observed collections. Your ARC Point folks know that, but it doesn't hurt to remind them. And then once they've passed that return to duty test, hopefully it's negative, doesn't happen all the time, then they are put into what we call a follow-up testing plan. And like you said, like we learned earlier, 6 tests in the first 12 months. And so you would want to make sure, again, on the authorization that you're very clear that this is a follow-up test. A lot of times people refer to follow-up tests as random tests. You don't want to make that mistake because if we do not do an observed collection, which is required for follow-up, then it doesn't count and you've just wasted the driver's time and wasted your money. So make sure that you're really clear when you send your folks over to your local ARC Point office that if it's return to duty and follow up, that you're marking that clearly so that we know to do that observed collection.
Eileen asks for random drug screens. Can the employees continue to work while results are pending?
Yes, for random testing, you can. Actually, the only reason for testing that the person has to be taken off work while you're waiting for a test result is reasonable suspicion.
Any
All
other
right,
questions? Oh, we
let's
got more questions. What do you want to do?
let's move on and then we'll come
Okay.
back.
All
Okay.
right.
All right, so clearinghouse update. So this is for those of you who have CDL holders. You know, the clearinghouse is the big DOT database in the sky where we have to report positive drug test, alcohol test results of 0.04 and greater, and refusals to test. Crazy facts. People are out there doing drugs. Last year we had almost 63,000 violations reported, and since the clearinghouse was first started in 2020, all over 313,000 violations have been reported. There are about 180,000 drivers that are still in prohibited status in the clearinghouse. The big thing you need to know, as of November the 18th, any CDL driver who has a clearinghouse violation will have their CDL downgraded within 60 days. And some states are moving more quickly than this. So when we have a violation reported to clearinghouse, the driver becomes prohibited in the clearinghouse, and the feds are pushing that data down to the states. The state agency that issued the CDL license has a maximum of 60 days to downgrade that person's license. If they can get through the SAP process within 60 days, we can stop that and we will help them do that. But just know that the downgrade is happening and it's happening fairly quickly. So the drivers should get a letter from the state if that applies to them, which is another reason that the driver make sure that your drivers know if they move, they should clear up their address or they should change their address on their license. I saw a driver just last week who got a ticket because when law enforcement stopped him, asked him to verify his address, it was wrong. So make sure that your drivers are clearly updating their license addresses with the state. Again, if you have those positive test results for your CDL drivers, they have to go through the return to duty process to get back into a not prohibited status. So return to duty process, Ryan has alluded to this a little bit. You have to make sure the SAP is qualified to do the evaluation. You need to understand the process. If you need help with that, contact your local ARC Point owner. They'll be happy to help. The driver has to go in the clearinghouse and designate the SAP. They go through the SAP evaluations or at least 2 evaluations. And then the SAP says they're good to come back to work, hopefully. And then you, as the employer, can request the return to duty test. You report that into the clearinghouse, and then they become not prohibited. That information also is supposed to be reported to the state. So just like the feds report the positive test and the prohibition to the state, they're supposed to also be reporting the not prohibited to the state once the driver has a negative return to duty test. And then again, they have to have those 6 tests in 12 months, and the SAP can require that to go longer if they feel the driver might have the propensity to relapse. So you as the DER, you have to have 3 things from the SAP. You have to have an initial evaluation letter. You have to have the follow-up evaluation letter. And then you have to have a separate follow-up testing plan. The driver cannot see the follow-up testing plan. They can see the first 2 letters, but they can't see the third. Make sure that before you put the driver back in the truck, you run a full query to ensure that the SAP has done all their requirements and the driver's not prohibited. We also, because of this CDL license downgrade, we also encourage you to check and double check again and make sure that you pull a new MVR before you put the driver on the road to make sure their CDL hasn't been downgraded. So after that, after the not prohibited or the return to duty test is uploaded to the clearinghouse, wait a couple of days. You do the query to make sure it's not prohibited, and then pull an MVR to make sure their CDL is valid. Again, make sure you have all those documents from the SAP. All right, we're going to move on. Our boat is moving down the channel. So oral fluid testing, we've been talking about that for a while. So in June of 2023, the DOT said we could add oral fluid or saliva testing to our DOT testing process. However, the labs weren't certified when the DOT passed that, so we've been catching up a little bit. The DOT did a great job, got the regulations out there, and then the labs had to catch up. So this will probably happen within the first 6 months of 2025. So we've got, a bunch of labs have submitted their certification packages to the feds, and we're just waiting on the feds to do their thing and to sort of get the lab certified. You can add oral fluid testing to your urine testing program. It does not have to replace it. We'll learn through our process today that you can even swap between them. If you start with a urine test and the driver can't give us enough specimen, instead of waiting 3 hours and drinking 40 ounces, you can flip to an oral fluid test. So you will have some options. Things that you need to think about when you're deciding whether you're going to add oral fluid testing to your program is number one, the collection process will not require a bathroom. We're just going to we can sit at a desk and do the oral fluid collection. It also minimizes their ability to cheat because we're not giving them a cup and sending them to a bathroom and shutting the door. And then just know too, the collection process will take a little bit longer than the urine test. Experienced collectors, we can flip out a urine test in 6 minutes flat. It will take longer for the oral fluid test collection because there is a waiting period and whatnot once we start the process. So, but again, they're not going to be able to cheat. So maybe the pros are better than the cons. Number 3, the look back period is shorter, especially for THC. So with a urine drug testing, we advertise that urine testing has a 14 to 30-day look back period, depending on their frequency of usage. The look back period for THC on an oral fluid test is much shorter. It's about 36 to 48 hours. Also, the drug can be detected much earlier after use. And so with a urine test, it's about 3 hours or so before the urine or before the drug has metabolized through and they excrete it through their urine. With a oral fluid test, the drug is in their saliva in minutes. And so if it's a reasonable suspicion specifically, or post-accident, and we want trying to make sure that they're not impaired right then maybe an oral fluid test might be a better option. Again, these are things you're going to have to think about, and you can talk to your local ArcPoint team, and they can help you with the guidance. So,
Hey, Les, I'm so sorry
yeah,
to interrupt, but we're at 159.
yep.
Uh, So however you feel you need to
Okay,
adjust
we're
to
gonna
get the two.
let's do. I tell you what, we'll finish this up. We'll ask some. If people want to stay on, we'll answer some questions and then we'll be done.
Unfortunately, I have 3 webinars back to back starting at 2, so I'll have
Okay,
to hop at that point, but you guys can stay if you'd like.
okay. Oral fluid testing. Again, we've already talked through that. Just make sure that you talk to your ARC Point folks about that. And then we will need to have complete a standing order. You're just trying to let your ARC Point team or whoever you're using for collections know when you wanted to use urine testing and when you want to use oral fluid testing. So this is coming down the pike. Stay tuned to your ArcPoint team. Pay attention to our social media. We're going to be pushing when the labs are certified and when we can do oral fluid testing, we will be pushing that out to you all. So just make sure that you stay tuned. We'll help you with the standing orders so that you can think through when you want to add oral fluid testing to your protocols. So if that's it, we're good.
Beautiful. What we can do is I see a bunch of people hopping off. They probably have to jump to other engagements. But I
Hmm.
have about 5, 6 questions, Les, which I'll forward to you. We can get those answered in the follow-up email. I
Okay.
want to say thank you so much. Isn't it so
Yeah.
refreshing, everyone, to have a bona fide expert for an hour to have their attention? Usually there's a question or two that I can't answer. I don't think there was one question that Leslie couldn't answer. So thank you so much, Leslie, for sharing your time and knowledge with us today. Thank you all for joining. And we hope that you'll join us again in March and April as we once again help you guys thrive in 2025. Have a great Thursday.
Thanks. Bye.